Yankwa, Lawyer Edudzi Tamakloe, MPA boss, Director Legal, NDC, and no Chiche and Combo. Now, I'm to say,
Onyame Adom Yahuye, now on so.
Yes, young Boko pa. I did be at that Daily Post in him. Was the office of the special prosecutor was born as a political tool for MPP. Uche mwaba was a special prosecutor in office no ya wono a na ye akadie bia eye amanyosema akadie bia ye de MPP for edema wo ho enkomo eti sei
Yo bra kwame se mekasa na de mejina sunyina ne se when we say politics any your governance system ewo my mohano 1992 constitution in a boying Emma Yedi Sajumadi no. Now, 1992 constitution now, Article 88 is very instructive. In Article 88 is acquire very entrenched provision. What we need or what will be aware or painful. When we say the constitution Emma provision be entrenched. What it tells you, say the framers no empese obi bia betimi a changing no at will. I just say okoye the FN referendum. What it tells you also, say the framers no a certain level of protection ama that particular provision. Into Brakwame, the akoba nyina say. Emra Article 88, 3 and 2, Emma Hukwain, and then repesi a bit of constitutional law. Ewohanum. We also say who the benefit of Article 88. But Ewo Fidi so. Hello, brother. Hello.
Produce. Wait, mommy.
Hello.
Kazo, mensa to me account. Me was meet you.
Article 88.3. Macho bet me account my ana.
Article 88.3. My men can you ready a woy. 88.3.
Yes, sir.
Me patro making kind.
Yes, sir.
The president may acting in consultation. Sorry,
88.3.
number 88. 883.
Yes, sir.
I say, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offences, with emphasis on shall.
I say shall be responsible, mandatory, and you understand?
I am mandatory. Everyone say, one so Article 11, one at can we no 88 no a wo say bedu baabi no enipa bi wo ho a wo mo so ma wo mo that quasi powers ni bia wo tum de yesa
da bi obi ani ho wo mamu hanu nti o kan Article 88.4 na ba jo kan no so ni ntie
Article 88 clause 4 of the 1992 constitution was say
yes, sir.
All offences prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with law.
So it is either or say all offences must be prosecuted by at the suit of the Attorney General. Criminal case it starts with the Republic versus two or say or a person authorized by him. Into Shaya, Attorney General, Emma Senate for a prosecuting for defaulting in Senate payments. Attorney General, Forestry Commission for Hong Kong, Game and Wildlife for say on prosecute will be because Onipana Kukum Abua Ewo Game Reserve are only permitted to do so. Attorney General ama Hukwain ama Smith for a prosecution Ghana Police Service for a day a prosecution. Now, the reason why Attorney General, in the wisdom of the framers, man is actually me say, well, I'm a prosecution is a public policy tool. Prosecution is a public policy tool. Into Oshaya, embedded in the power to prosecute is also the power to enter nolo prosequire. Sebi. Ye Ghana, ye want him for, by ye want him for. And yen is Inti, se Ghana, ye want him for, by ye want him for.
I be the BH.
I have for Chimia, a biddy BH. Sebio, Sekoba say, the prosecution of, say, a particular chief can invariably undermine the national security of the state. Nothing stops the Attorney General to say, in respect of such and so person, I will not prosecute him. Anything Attorney General will be to me to enter the FN nolo prosequire. And now, nolo prosequire power no. The Supreme Court in the matter of Gregory Afoko and the Attorney General, and so Eddie Abetu just say the power by the Attorney General to enter a nolo prosequire is not judicially reviewable. In the sense it says, which means court and challenge Attorney General say they in a case where we why you say file a nolo prosequire. In fact, the reason why Afoko shall not buy no okay Emra Gregory Afoko Ninsem eba ye omude no call court man bill. Okay, at that time, Attorney General of the land frustrate bill na last minute. So okay, back forth. In a go through a full trial. Attorney General calling the witnesses before Justice Ellen Mensah, a justice of the Court of Appeal, sitting with additional responsibility at that time. Judge left for judgment too. One Attorney General say, you know what? I'm entering a nolo prosequire. And I focus say, why? What the whatever it is, Attorney General show wakoche the co-accused was Ivory Coast. In view of that trial, I go through in absentia. Yeah, fair witnesses, no, almost started, and now they are filing a nolo prosequire and starting the prosecution afresh. I focus on that. Don't waste me time. I've gone through a full trial. You can't do this nolo prosequire. No, you can't do it. In an Oko Supreme Court. Supreme Court say, Afoko, we are sorry. Yes, it is. Yes, the evidence shows that you've gone through a full trial. Witnesses have been called. But you know what? The power to enter nolo prosequire is not judicially reviewable. Into that ends it. So go back and start the trial afresh. Into that say Attorney General. In fact, case no now certain member Lord Justice elements our call retirement. Into now say omofa case name call Justice Wood a honor into the case has to start all over. The reason why I'm bringing this matter is to let you know, Sir Family, the power to prosecute is a unique power. Into the framers of the Constitution, in making the Constitution, almost Shada put it at a very entrenched constitutional provision, which requires only a referendum to change it. Obi Wako Law School, and said, you cannot use an ordinary act of parliament. So, Ubet may use an act of parliament to amend the constitutional provision. Entrenched
council, but what do you be one person making kind of a conversation?
Excellent.
Say the Office of the Special Prosecutor Act 2017 Act 959 establishes the OSP and situates its authority within Article 88, Section, and then Section 4.2 also provides that the special OSP prosecutes subject to Article 88.4 with authorization by the Attorney General. Properly understood, the provision recognizes the Attorney General as the constitutional source of authority. It does not require that authorization be case specific. That form is supplied by 959 and its subsidiary instruments, including LI 2374. Where are you saying?
Complete misunderstanding of the law. You see, OSHA, the Criminal Offences Act, the Criminal Offences Act, Procedure Act at 30. OSHA, there is an insertion in that provision in tandem with Article 88, where the Attorney General is seen authorizing the police to prosecute on his behalf. When the police prosecute, our will be also independent there.
Oh, there be.
Good. The submissioner, whoever it is making in that case, no. If the argument is anything to go by, then the Office of Special Prosecutor cannot be independent of the Attorney General. The people who make the argument, that argument, no. The flip side of it is to say, if you are prosecuting on the authority of the Attorney General, can you be independent of him?
There be send the budget no crowd about parliament. Just say a deba Attorney General.
Attorney General. Onankasa any audience before Parliament. Because he's considered like local to be an institution under the office of the Attorney General. Until the budget is presented and is approved. But even that's financial independence. But in terms of prosecutorial independence, Oshaya, at the time of the parliamentary debate, Brakwame, Obian said there was a problem. And that is where I introduced the idea, say, the whole idea of setting up the office of the special prosecutor was a political campaign promised by the NPP. Do you know why?
Why?
Good. Okay, yeah. And now President Rawlings said, now, 2 million Manifi year 2000. And I President Kufobaye. President Kufobaye, no, and I appointing another Danko Kufado as the Attorney General. So, okay. And run another Baye Attorney General. No. He started some prosecutions, effected some arrests. The Republic versus Chachu Chikata. The Republic versus Victor Solomon. The Republic versus Juan Petra, Ibrahim Adam, and others. George Payanke, Quality Green Matter. And several other cases within the period of 2001-2008. At that time, the conversation was that Shedio Omanpeni Kufo from 2001 to 2008, and Kufo and Abai a prosecutor Munina were NDC appointees, with the exception of Malam Issa. Okay, Malam Issa,
Sports Minister, no? Aye.
Sports Minister. In fact, you are the only person. No one yet NDC appointee that was prosecuted within 2001-2008. And no plan a PNC ni. So the conversation became so ripe, say, all the prosecutions were partisan in nature. And so, there was this conversation, okay, how do we resolve the problem? Sir, you bet me any prosecution, Ubi and Kasi a witch hunting. It's okay, yeah. In the 2016 manifesto of the NPP, the idea of setting up this independent office came about. Immediately, then they started the process to introduce the bill to Parliament for the establishment of the office. Look, I have the Hansard, the Parliamentary Hansard of 1st November 2017. during the second reading, the consideration of the bill as introduced by then Attorney General Mohammed Gloria Kufu. In that conversation, you see MP saying, say, even the U.S. Embassy was effectively putting pressure on the government at that time. It is captured in the parliamentary answer. In fact, the U.S. Embassy brought in a memorandum saying, say, the office should be, devoid of political interference and influence. It's captured in the parliamentary answer. But that time, something more instructive happened. At that time, now Nanado Abe president, mindful of the things that now also and no Attorney General. Obia who said there was a constitutional roadblock. But the government at that time, with pressure from civil society groups, pressure from the U.S. Embassy and other donors, yes, okay, we will ignore that constitutional roadblock and still go ahead and set up the office anyway. Anyway. Look, Kwame, we share a debate that ensued between then Speaker Michael Quay and the Honorable Dr. Dominic Ayeni, a member of Parliament for Bolga
Central.
No, Bolga is. I think I don't go here Central.
Okay.
Already a very important point before Speaker Michael Quay. And I just want to read the interaction. Now, Honorable Banda, Abdullah Banda, so you know. Now, the ranking on okay. I think official. Aha. You know, I'm the chair of the Constitutional Legal Affairs Committee of Parliament. So you are the chair. And this is what he said. He said, Mr. Speaker, so with your permission, if I may move item number Roman numeral XB11 and so, then he proceeds. Then Dr. Ayene comes in. Mr. Speaker, then Okwe Bisano, any objections? At the time they were considering the clause by clause, section 4(2). Mr. Speaker Bisano, Ayene, any objections? I said, Mr. Speaker, I wanted to propose a further amendment to section 4(2) because we have not indicated the mode of authorization by the Attorney General. Translate to money.
Shall save you.
Also, Mr. Speaker, I wanted to propose a further amendment because we have not indicated the mode of authorization by the Attorney General.
Okachire Speaker no sabre ni say. Kamesu to say. Section 4(2) no a what special of the office of the special prosecutor ne bill no mu aye di ho gbogbo yi. Ka yentwe we esan say enchire ekwan a Attorney General no ebefa so ma ne tumi pote.
So I'll say then you proceed. So I wanted to propose, not you. So I wanted to propose that she is authorized by the appropriate legal instruments.
Sena kamedi me famudia enkebe ya kayempe ayi enhye bia enam mremu a ebetimi ama ne tumi ama ne tibia na adwuma special prosecutor.
Then Speaker Okwe comes in. Where appropriate, legal process of authorization means what?
One yeura Speaker Okwe sabre no bebu sane say de wo kan pa say ye ma ne tumi na tumi no enye tumi enam mremu no opese o kire say.
Then the Honorable Ayene comes in. Also, Mr. Speaker, for instance, she could do so by a constitutional instrument or by legislative instruments where it was spelled out clearly what the jurisdiction of the special prosecutor is.
Wasi o mira die betumi aye ne se ye betimi de amamra mu nsem bi egu ho a enam kwan so poten a kire se awno mi tumi no oji firi he ne he no de be kwakoduro na se no de be yo.
Then he proceeded or say, this is because what we are doing here is to say that Parliament is by a statute making the Attorney General authorize the special prosecutor. But she's the one who is delegating that authority. And there has to be a mode of delegation.
And now what Chemunan was a dear yen wa hey, ya koyese, Parliament in Equa money to me, a money dear ye no, a dear no, a one, Attorney General, ban lawyer penino, and a sesse, and Kawutimi share, now what money, be say a dear way, media show and sa, koyo, way media show and sa, koyo, ewam.
Rapame, Obibia Wako Law School behind him say, who need to mean delegate, and
yes.
You can't delegate an authority you don't have. Rapame, can you delegate an authority you don't have?
Debbie.
The authority to prosecute is exclusive to the Attorney General. Under Article 88, does Parliament have the power to prosecute?
Ebi, argument so yen say subsidiary laws num ni ade bata Parliament is clothed with that powers. Mra hye ni nyina so argument no.
Your constitution emma separation of powers, and that's why the president cannot legislate. Legislation is exclusive to Parliament. The president can only introduce the bill. Now, even private member bills are permitted. What does it? Parliament does not have the power to prosecute. So how can that Parliament that does not have the power to prosecute purportedly delegate that power to the OSP? It's a legal scam, legal fiction. It's a legal impossibility. There is a popular Latin phrase, almost a delegatus non posse delegare. You can't further delegate a delegated power. Sebe. Parliament, because you don't have the power to prosecute, you cannot delegate that power to any other authority.
Me pacho ebra Parliament pass him ran pa. Now the rationale behind and say.
You see, at that time, like I pointed out, now 2016, the major campaign promise of the MPP was that the Mahama administration and the appointees were corrupt, and therefore they wanted an office. Anything American say was partisan political. They wanted an office to lead that hounding. And that is why the first special prosecutor, Manado decided to go for the respected Martin Amidu. Because at that time, the circumstance under which Martin Amidu, he was not happy. And always remember, say, Martin Amidu has always been a foundational member of the NDC. Intikwanya, only Professor Mills' relationship, I say, yeah, okay, the way you may matter. At the yaw, at the ban. So at that time, the president of the republic at that time felt say he had gotten a perfect opportunity to exploit the anger of Martin Amidu against President Mahama and his appointees. Unfortunately, like the story between Haman and Mordecai, a flippy. To the point to say, Martin now decided to do the corruption risk assessment on the Japa deal. Whereupon he implicated the cousin to the president, Ofori Atta. President Akufo-Addo tried interfering by arranging a meeting between him and Martin Amedu. Martin considered that to be interference. And more sure that report, on the corruption risk assessment in a day until and Kasakasa Eba on President Akufo-Addo and Tim. Eventually, he ended up describing him as the mother serpent of corruption. Okay.
Hyper that episode.
Na akoye say Hemana wasu fidie ediama Modekaya and the same fidie na wasom ama Modekaya no ohene no say eyawawodia. So Martin had to resign for Mr. Kissie Jaben to take over. And I've always maintained that the problem is not Kissie Jaben. In fact, during the parliamentary vetting of Mr. Kissie Jaben to occupy the office of the special prosecutor, the Honorable Mahama Yaga ebisano 1 or 2 questions on this independence of the office. And one question to say no. All looking at the OSP Act and the Constitution 1992, Article 18.34 now, clearly there was a problem. So even him, at his vetting, I'm sure the video is there, you can play it to your listeners. On one side, he said there is a problem. But you see, the problem was created before Kissie took over. And by the time he took over, there was very little that he could do to salvage the problem. Now, Abed Dane, an issue that he has to resolve. And that is where we are. So, Kwame.
Council, answer you better was one. The Leonard Thavio sorry. Extra a letter be now 1.5 no was say a dear na OSP Mrano Kappa special prosecutor an appointment was say rather than providing for an independent or popularly accountable process such as selection, as is the case for parliamentarians and president, the law mandates that a special prosecutor be appointed by the president. Which was saying that OSP in law no ekafa SP no appointment ho. Senke beba beto abane baby bia na enya independent no. Emra ne say this is a president no and appointing no according to the Leonard sorry. And was the same president no and as appointed attorney general. Intino na bia ka say okay officer no lucky insufficient independence no. Ono president na appointed it said you are appointed attorney general na the argument is say so case one ne pass one ne pay nyina president appointed yen
one we say bra kwa America attorney generals are elected. What do I say? Attorney generals are elected.
Yes.
In fact, we know Kansas is here. The U.S. Attorney General for New York, the state of New York, Letitia James, President Trump has asked that she be prosecuted. What do I say? Because said you on President Trump the political party. But you see, the challenge I have with the position taken by my senior and say, you can actually achieve some level of independence, not necessarily through election. Why do I say so? Constitution ankasa Emma Hukwan say Omampeni ebe nominate or appoint justices of the Superior Court. And yes, sir.
Sanity.
Into Omampeni be appointee a Supreme Court judge. However, the Constitution provided a safeguard. What is that safeguard? Also, so Mampini appointing Ubeko Parliament for vetting. It is a way of insulating the office holder. And Kwame, the reason why you want that provision and the security of tenure provision in the fair. Ghana Yabako said. Into the 1992 Constitution, one of the things we always see is it mirrors our history, our checkered history. Okay, tell you Adamafio.
Tell you Adamafio, aye.
the trial of Tayo Adamafio and co. That trial, that is now, it's now a case, no, acquitted and discharged them. So,
Kaipa.
What did Nkrumah do? They say Nkrumah do for ye, Emma, you judge for no Eddie. Because those were persons that were considered to have engaged in treason. They were into a minor, into a minor. And so, at that time, the expectation was that at least there will be conviction of them. But the judges said no. In fact, I think that was the case where they said a multitude of suspicion is not enough to prove the guilt of an individual unless there is concrete evidence of wrongdoing. In Tisaja no, Omo acquitted the charge, Tayo Adamafio and Nkekahon. The president of the land was not happy. It is based on that history, no, Brafame. And why 1992 constitution, in the day, the security of tenure provisions needed to say. Even though Oman Penin appointed as a superior court judge, high court judge, Oman Penin appointed, Court of Appeal judge, Oman Penin appointed, Supreme Court judge, Oman Penin appointed, Babeko parliamentary vetting. But on your appointment in the now we go through parliament for that vetting. Now Oswell in Sa Oman Penin ain't me a you unless Article 146 is triggered. What does here? And on only 3 important grounds: Sebe, infirmity of body. Why you have become incapacitated. Which means to us be on. Obey you. And I say, we are incompetent. We need Juma. And I say, the friend is stated misbehavior. Without this, Oman Penin to me you will do because judgment now or they buy many angel. All these things are safeguards. So I would, with respect, differ slightly with my senior Tadiosori on this. Election is not the only way. At least the constitution has a roadmap. What do not call parliament, any of those things. Yeah, there is security of tenure provision. Which may you nipan only. Special prosecutor say the attorney general does the nomination. You go through parliamentary vetting. Your vetting, yeah. Almost say, which may you need only based on the grounds for the removal of justices of the Superior Court. That is what the law says. So it is not only through an electoral process now, which may anya that strong or independent way. But that, you see, nomination to occupy an office is distinct from what you do when you occupy that office. That is the confusion. I have heard some scholars make the point, say, to the extent that it's the Attorney General who nominated Kisi to occupy that office, it meant he has been authorized. How can you make this argument?
Another post to be by one Alexander Abban. Police and snitch prosecute without permission. So should OSP. Lawyer Alexander Abban. Me pacho wamu prosecute under EI from the Attorney General. So FDA for 851 EI 851 Bank of Ghana 930 and 1032 day and we number the firm keke. It is OSP 1 year day and I young train my Supreme Court and ruling number on the interpretation of Article 884 per the co-warranto issues no many idea. Who's to say any day?
Last year when NDC MPs been bring this issue about the special prosecutor, no, Ghana man penny, President John Dramani Mahama. It might simply so can say, no. We can't have that conversation now, and that the OSP should be given time to prove its worth. So, okay. In fact, and that is how President Mahama basically stopped that conversation. Two, President Mahama, okay, yeah, Emra, two NDC MPs at the private members' motion, the General Secretary of the party came out to say, no. The party has not been informed.